I want to pick up where my distinguished colleague from the great state of Ohio left off on the sanctuary cities conversation. Mr. Hansen, I assume you're familiar with President Trump's executive order entitled Enhancing Public Safety in the Interior of the United States?
I am.
And Section 9A orders the Attorney General and the Secretary to ensure that jurisdictions that willfully refuse to comply with 8 U.S.C. 1373, so-called sanctuary jurisdictions, are not eligible to receive federal grants. Is that right?
Yes, that's correct.
Now, in the previous fiscal year, New York City, so-called sanctuary jurisdiction, received $4.3 million in burn justice assistance grant funding that it could lose under this order. Is that right?
That's correct. Good.
And on Friday, the 21st, as I believe you just testified, the Department of Justice sent a letter to New York City and maybe other cities asking New York City to demonstrate its compliance with Section 1373. Is that right?
That's right. That was April 21. That was a reminder letter of the requirement to do so, yes.
Okay, but are you aware that federal courts have found that policies that limit or prohibit compliance with immigration holds and requests for notice of relief do not violate Section 1373?
I'm aware of ongoing litigation surrounding the sanctuary cities issue. I'm not sure if I understand that particular limitation you described.
Okay, well, let's go through some of the jurisprudence that exists. According to the United States District Court, Northern District of California, in the Steinley versus City and County of San Francisco case, Section 1373 only prohibits the enactment of certain policies about sharing immigration status information. It does not command the states or cities to administer or enforce federal law. Was that the holding of that decision?
I'll be honest, I did not read the entire decision, but that is my understanding of it, yes.
Okay, and then the Third Circuit, Pennsylvania, New Jersey, I believe the Virgin Islands, in the Galarza decision, I believe held, immigration detainers do not and cannot compel a state or local law enforcement agency to detain suspected undocumented individuals subject to removal, and, court's holding, electing not to respond to them is entirely within the discretion of local law enforcement. Is that your understanding of the Third Circuit's decision?
Again, I have not read that opinion, but that's my understanding.
Okay, now, are you familiar with the Supreme Court's case in Arizona versus the United States?
If you mean from a few years back, I am.
That's correct. And that decision held, nothing in federal law requires localities to enforce immigration laws and regulations, correct?
Yes, that's my understanding.
And I assume you're familiar with the 10th Amendment?
Also, yes, familiar.
And the 10th Amendment precludes the federal government from coercing state or local governments to use their resources to enforce federal laws or regulations like immigration. Is that correct?
That is certainly a fair interpretation of that, yes.
And that's a concept known as the anti-commandeering doctrine, correct?
Yes.
And the Supreme Court has continuously upheld the anti-commandeering doctrine, correct?
I believe that's correct, yes.
In fact, Justice Scalia, may he rest in peace, who was obviously a conservative, I'm a progressive, but had great respect for his legal mind, when he struck down in Prince versus United States key provisions of the Brady Bill, stated, it is an essential attribute of the states' retained sovereignty that they remain independent and autonomous within their proper sphere, and that they should not be, his words, dragooned, very creative, dragooned into administering federal law. Are you familiar with that decision?
Yes, yes.
Chief Justice Roberts, again, conservative, I'm a progressive Democrat, Supreme Court decision in NFIB versus Sebelius, which struck down a few provisions of the Affordable Care Act, noted that if you forbid funding conditions that are so coercive, they amount to a gun to the head of the state or local government, and that is inconsistent with federal law or the Constitution, correct?
Yes, I recall that ruling.
And so I guess, in closing, my time has expired. I can't understand why the Department of Justice, which is the entity that should administer the law, faithfully execute, as well as the Constitution, can conduct themselves in this fashion, notwithstanding clear judicial precedent from the Article III branch of government to the contrary, including decisions written by some of the greatest conservative legal scholars ever to exist in this great republic. And I would hope not that you would listen to the voices of those of us on this side of the aisle, but listen to those who have consistently articulated decisions anchored in the valued precedent of federalism in this great country. I yield back.